Hello, hello, hello. Welcome everyone to another episode of Bark a Lot. I realize I very last minute ended up not being here last week because we had a party and I actually triple booked myself. It was Pride in Portland and we had a party here at the house. And I'm back this week. While I'm chit-chatting here, let me know where you're coming in from, what you're sipping on this evening. And so we are here tonight. There will be no show next week. Next Saturday is the 4th of July. I've got things to do, you've got things to do. It's gonna be a whole thing, and then we'll be back on the regular schedule. If you are on the email list, I sent out a list of things that I am looking at. Let me know, even if you're not on the email list, if you want to be on the email list, scoot on over to barkslotmedia.com. You can get on the email list there. Before every show, I send out a little blurb about what the show is going to be and that kind of thing. But it's also where I go first to find out what you guys are interested in me covering. So it also has links to the shop and if I am writing any sort of a blog, that's there. Memberships are there. It's all over on boxerlotmedia.com. So head on over there and check it out. I am at some point I will figure out how to get video over there as well. So that it's not just on YouTube, but I like the YouTube. So we hang out here. So welcome. What am I sipping on this evening? I have a gin and tonic. It's pink because I also do tea as ice cubes. And so this is a hibiscus tea, which has a lovely little flavor. Fun fact, if you don't know, quinine in tonic water helps keep the mosquitoes at bay. So if you, like myself, get eaten alive at this time of year, quinine, baby. A little bit of tonic water. I like a splash of gin in my tonic, but I also just like tonic. So, let's see the disclaimers before I go ahead and get going this evening. I'm not an attorney. So I am a legal biller and I watch a lot of lawyers here on YouTube. So I've picked up a few things. Um, but none of this is going to be legal advice. So what's on the docket for tonight? Well, I've seen the headlines that Katie Fang won her lawsuit to get a lot more of the Epstein files released in the way that they are supposed to be released. And I was able to find the documents. So, I love a good document. We have the documents. I have no idea how long this is going to take. Probably a minute because the decision is 48 pages and the complaint is 15. I'm skipping over everything in the middle. We're just doing the beginning and the end. I have not looked at them before, so this is going to be a first look for me. I've heard of this. I've been sort of tracking it, but I have not read any of these. So this is going to be a first look for me. That's where we're starting. I hope everybody is doing well. Thank you so much for joining me. Before I forget, because I always do, if you like the show, if you like hanging out here, yay, I love that. Go ahead and tap the subscribe button and go share with the friends of yours that you think might also enjoy this. There is nothing more fun than being at work and insert YouTuber here, talking about the latest episode. It's like appointment television again. I don't know. It's kind of fun, and I love that. So, do all the YouTube things, and if you have seen some of the merch, I'm wearing my Pride shirt today. My Be Well, Do Good, Bark a Lot Pride shirt. It was created with the help of AI. I'm hoping that was a one-time thing. It was last minute. The goal is for this to be the only AI thing ever in the shop. But full disclosure there. So anyway, I'm going to go ahead and roll the intro. We will dive right into it. Get yourself comfortable. Get yourself a beverage. We've got 15 pages of complaint and 48 pages of decision. So it will be here for a minute. I had another thought. I can't think of it. So Aurora, just roll the intro. Welcome to Bark a Lot with the Aurora H. White. I'm a legal biller by trade, opinionated law and politics nerd by default. I'm here to break down the political, pop culture, and court headlines that we're all talking about. We value facts, thoughtful discussion, and salty language, so whether you're a fellow law nerd, a political junkie, or just looking for a little hope in today's crazy world, you're in the right place. Tap that subscribe button, pull up your soapbox, and let's go. Let's go. I'm realizing I need to change a couple photos in that intro there. Because I have new ones and they're so much more fun. I love the other ones too, but I like the fact that I have a genuine smile in some of the new ones. So, gotta give the intro a wee zhuzh. All right, I'm going to start with the complaint. This is what started it. This was filed April 27th of this year. Why? Because we weren't getting as far as we wanted with the release of the files. And so Katie Fang, not only being a journalist, but also an attorney, went ahead and filed a lawsuit. So we know if you follow Emily D. Baker, you know that any of the attorneys online, but I think it started with EDB. Complaints are allegations and shades. So I admit I started reading the first paragraph of this, and Katie Fang does not disappoint with the shade. So let's go ahead and take a look. This is what the court had to decide on. This is what they had. I think there were some hearings. I don't think it was all motions, but it was a short docket. It was a little itty bitty docket there. So let's take a look. So this is Katie Fang suing Todd Blanch in his official capacity as Attorney General. The introduction to the complaint, or complaint in the introduction. If I go back and forth, it's because what is in front of me is super, super tiny and hard for me to read, and I can't figure out how to make StreamYard make this screen bigger, so I'm probably going to be looking over at my other screen here. So, this case is about defendant Todd Blanch's brazen, shocking, and ongoing violation of the Epstein Files Transparency Act. That is one heck of a way to open the complaint. Props. I'm a fan. Since Jeffrey Epstein first pled guilty to sex crimes in 2008, and especially since his death in 2019, public interest in his actions and network, the Epstein elite, has been extraordinarily high. A wide swath of the American public continues to suspect that Epstein and his co-conspirators committed crimes that were never adequately investigated, prosecuted, or punished. Accurate. Yes, we do. In November 2025, in the face of extraordinary and sustained public pressure, Congress passed and the president signed into law the Epstein Files Transparency Act, the Epstein Act or Act. The act required the Attorney General to produce, with limited and precisely enumerated exceptions, all documents held by the Department of Justice or the Federal Bureau of Investigation concerning Epstein, his alleged co-conspirator Ghislaine Maxwell, any other individuals named in connection with Epstein's activities, and any entities known or alleged ties to Epstein's activities, among other things. Let me see if I can summarize. Hand it all over. Stop with this drip, 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 and a whole lot of redactions. Like, no. Going back to the complaint continues. The act further required the government to produce these documents within 30 days of its enactment, not later than December 19th, 2025. That required production never occurred. Put simply, Defendant Blanch, the former Attorney General and current Acting Attorney General of the United States, has failed to comply with the law. Under Blanch's and former Attorney General Pam Bondi's leadership, the Department of Justice has failed to produce the required documents within the time required. We could have proofread that. I get where the double required came from, but it has improperly redacted documents and failed to adequately explain those redactions, and it has either retracted or failed to produce entirely documents that should have been produced. All of this facially violates the law. She's not wrong. It goes on to say defendants' failure to follow the law. Pausing here, interjecting with myself here, if you're just listening. The number of times she said the Attorney General has broken the law is truly epic, and we're only on paragraph 8. I am here for the shade. Continuing, defendant's failure to follow the law has named plaintiff Katie Fang, a journalist, lawyer, and legal analyst who has extensively reported on Jeffrey Epstein and his network. I'll use this as the opportunity to say I do have her YouTube channel linked in the description of this video. She is an independent journalist, legal analyst, all of that. Go ahead and go give her a follow. And then come on back and we'll finish this up. It goes on to say Fang's inability to report with substance on all of the documents she should be able to access has hurt her ability to do her job and made it harder to fulfill her mission as a journalist and legal analyst. Fang brings this case to compel defendant to produce all of the documents covered by the law with impermissible redactions removed and with permissible redactions adequately explained. The Epstein Files Transparency Act demands nothing less. 10 out of 10 the writing on this. I love that. Parties, this goes into who it is, Katie Fang, Todd Blanch. Jurisdiction and venue, where is the court going to, which court are we going to? That's that. I'm skipping these because it's beside the point. Statement of facts. A, Congress passes the Epstein Files Transparency Act. Jeffrey Epstein was a convicted sex offender who in 2019 was charged by the United States Attorney for the Southern District of New York with sex trafficking and conspiracy to commit sex trafficking. Investigative reporting by a range of news outlets revealed that dozens of powerful men and women, love that, socialized with Epstein. I don't love I love the writing. Sorry, I realized I said that and I was like, oh, no, I don't love any of the crimes that happened. But I do love the writing of the complaint. Let me back up. Investigative reporting by a range of news outlets revealed that dozens of powerful men and women socialized with Epstein, raising the possibility that other people had committed crimes too. Yep. Mention it all. Epstein was found dead in his jail cell while awaiting trial. His death ended the chance of a trial that could have shed light. Words are hard. That could have shed light on his actions and his network of co-conspirators. But his health did not end the public's desire for answers. And in the years that followed, both citizens and politicians demanded the release of the so-called Epstein files, the investigative documents that the government processed concerning Epstein, his co-conspirator Ghislaine Maxwell, and other members of the so-called Epstein elite. I do like her alliteration. In November of 2025, after months of mounting public pressure, we already heard this, Congress passed and the president signed into law the Epstein Files Transparency Act. I'm going to skip some of this because we already know the act required the attorney general to turn over everything under the act. And then we go through the timing. Here's what so I'm skipping ahead here. Under the act, the government was allowed to redact or withhold documents under only very limited circumstances. Specifically, documents could be withheld in whole or in part if they, A, contained personally identifiable information of victims or information that, if disclosed, would constitute a clearly unwarranted invasion of personal privacy. Translation: any victim needs to be the one to decide if they're going to be public or not. For many of them, that choice was already taken away. And if disclosed, would constitute clearly unwarranted invasion of personal privacy. I think that relates to, I believe that would legitimately cover staff, drivers, other employees, people who went to a party or people who went to some of these parties, but maybe they were studio parties or something like that, where they're in the files, but they aren't necessarily intricately connected to all the rest of this, right? Does that make sense? So that's what that is. Other things to be redacted: B, showed child sexual abuse materials. Yeah, the general public does not need to see that. We save those things for juries. C, would jeopardize an active federal investigation or prosecution, and in such case, only if such withholding was narrowly tailored and temporary. What does that mean? Well, you know how the call for a lot of people, why didn't Biden do it? Why didn't Biden do it? Well, for some of this, Biden, and by Biden, I mean Merrick Garland, did not release any of these, in part because there was an active investigation and trial happening with Ghislaine Maxwell. So at that point, you have to hang on to it. But when that trial is done, then you release it. I think the other thing with Merrick Garland, speculation on my part, they were so focused on decorum, and some of their folks are riddled through there as well, that they decided to just keep shoving it under the rug, which I don't love. So that is what would be considered narrowly tailored and temporary. Showed images of injury, death, or physical abuse. Yeah, the real nasty stuff, that can all be redacted. Contained information specifically authorized under criteria established by an executive order to be kept secret in the interest of national defense or foreign policy. I'm sure there are broader behind the scenes fights that happen when it comes to national defense or foreign policy, but if you have the right people making those arguments, I'm fine with that. Further, I came across a phrase that I got confused by. This is a first look, by the way. So, further cabining these limited restrictions, the act directed that no documents were to be withheld because of their political sensitivity or because of the embarrassment or reputational harm that their release may cause government officials, public figures, or foreign dignitaries. Translation: we don't give a fuck who you are. We want to know if you've crimed. Because these are horrific crimes, and we do not care who you are. We want to know if you've crimed. The act also required the Attorney General to make two separate and specific disclosures. First, the act directed that, quote, all redactions must be accompanied by a written justification published in the Federal Register and submitted to Congress, end quote. And then there's case law. The second act directed that within 15 days of the completion of the release of documents, the Attorney General would submit to Congress a report listing one, all of the categories of records released and withheld, two, a summary of redactions made and the legal basis for doing so, and three, a list of all government officials and politically exposed persons named or referenced in the released materials. That's fair. They also need to provide an index saying what they've done and why. The Department of Justice fails to comply with the act. The Department of Justice failed to comply with the law. That is a sentence I shouldn't have to read out loud, by the way. The Department of Justice, the top dog for the United States court system, the DOJ, failed to comply with the law. Okay. It did so by ignoring the Act's deadlines, by failing to redact sensitive information, by redacting information it should have disclosed, by failing to explain its redactions, and by redacting, retracting, or withholding entirely materials about Donald Trump and others. Yeah, it's a weirdly specific group that is just being hidden. Then she goes on to allege delays. The department failed to comply with baseline requirement to produce the required documents within the timeline required by the statute. Specifically, the act required the full set of materials be produced within 30 days. We've already heard that. Trump signed it into law. I apologize for the yawn. It is warm up here. And I'm reading, and that happens when I read sometimes. Let's see. Let's jump down. I'm skipping over stuff we already know and stuff that is, they're allegations here, but they're pretty easy to fact check, and they are correct. So, specifically, the act required that the full set of materials be produced within 30 days of its enactment. President Trump signed the bill on November 19th, 2025, putting the deadline for production at December 19th, 2025. It was supposed to be a Christmas present. Just saying. On that date, the Justice Department released a mere 3,965 files. I think Proctor's text messages is more pages than that. I'm just saying. Then Deputy Attorney Todd Blanch conceded that the government had failed to follow the law, saying in a December 19th interview that, quote, today several 100,000 files, and then over the next couple weeks, I expect several 100,000 more, end quote, were or would be released. The actual number of files released was several orders of magnitude less than Blanch promised. The writing is just so great. The department published additional materials on December 20th, December 22nd, and December 23rd, 2025, and on January 30th, 2026, all past the statutory deadline. Concurrent with its alleged final production on February 2nd, 2026, the government released a 6-page letter purporting to summarize the categories of records withheld and the legal basis for the redactions made. In the letter, Blanch wrote that, quote, today's production marks the department's compliance with its production obligations under the Act, end quote. Incomplete redactions. In its productions, the department failed to make many necessary redactions with devastating consequences. So many victims. So many victims had their names just put out there as a whoopsie doodle. Redactions aren't whoopsie doodle things. That's my own thoughts. You don't whoopsie doodle the names of victims. It's frustrating. The complaint goes on to say, among other things, the department released dozens of photos of nude young women or girls, which was horrific. Quote, it's hard to imagine a more egregious way of not protecting victims than having full nude images of them available for the world to download, end quote. One of Epstein's victims said, elsewhere, at least 43, keep reading, Aurora. Elsewhere, at least 43 victims' names were revealed, including more than 24 victims who had been abused as minors. Some victims' names appeared over 100 times. Lawyers representing victims said that the government released, I didn't know it was that many times. Again, allegations and shade. The complaint goes on to say, allege lawyers representing victims said that the government's release of the materials was the, quote, single most egregious violation of victim privacy in one day in United States history, end quote. If that is true, that is even more disgusting than I thought it would be. Ultimately, the department removed several thousand files in response to victim demands. Hey, look, the regime did something right after they got yelled at. The complaint goes on to say unexplained redactions. In its productions, the department redacted thousands of documents, some in their entirety. The government's first production, for instance, included a 119-page grand jury transcript, the contents of which were completely redacted. As were over 400 pages of other documents in that initial production. None of the redactions was accompanied by a written justification published in the Federal Register and submitted to Congress as required by law. And she cites the act. Importantly, this requirement is separate from and in addition to the government's obligation to produce a report summarizing the categories of records released, the redactions made, and the legal basis for those redactions. Basically, okay, so part of this act was you not only have to release these files, but you also have to put them in order, categorize them, and explain why you did the things that you did. So that when people go to report on this, they are not just trying to sift through just a mountain of information as you get there. Like this is okay. Back to the complaint. Inappropriate redactions. Many of the redactions the defendant made facially conflicted with the requirements of the law. For instance, the department redacted the identities in a draft indictment of people who allegedly conspired with Epstein to, quote, persuade, induce, and entice individuals who had not attained the age of 18 years to engage in prostitution, end quote. The identity of the person who wrote to Epstein in 2014, quote, "Thank you for a fun night. Your littlest girl was a little naughty." God, I hate reading that part out loud. It's the end of the quote, by the way. The identity of the person who wrote to Epstein in 2017 that I met redacted today. She's like Lolita from Nabokov, femme miniature. So how should I send you her type of candidates only? End quote. Also, if you're somebody that thinks that Lolita is a love story, it's not. Please don't go there. That's just my side note. The identity of the person who wrote to Epstein in 2018 that, quote, "I found at least 3 very good young poor, but we was so tired," end quote, and that, quote, "Meet this one, not the beauty queen, but we both likes her a lot," end quote. The identity of the person who wrote to Epstein in 2013 that, quote, "New Brazilian just arrived, sexy and cute, 19 years old," end quote. And the identity of the person whom Epstein wrote in 2009 that, quote, "Where are you? Are you okay? I loved the torture video," end quote. If you feel like you need a shower after listening to those quotes, congratulations, you have a soul. The complaint goes on to say the act does not authorize defendants' redaction of those names. Context makes very clear that the redactions of Aurora, try again, makes very clear that the redactions are names of potential co-conspirators, not, quote, "personally identifiable information from the personal or medical file of a victim or child witness," end quote. I'm not gonna, yep, it includes terrible images of children, depictions of injury, death, other awful things, nor were the redactions necessary to protect sensitive national security or foreign policy information. To the contrary, the government has conceded that nothing was redacted on the basis of national security. This leaves only materials that would jeopardize an active federal investigation or prosecution. But after the department's final production, Deputy Attorney General Todd Blanch announced that the information released was insufficient to bring further prosecutions and that the department's investigation into Epstein and Maxwell's sex trafficking operation is over. So, by Blanche's own words, nothing to see here, folks. Please move along. But they didn't then follow up by unredacting the names of these folks so that state courts can determine if there should be crimes prosecuted. It's clear the federal court won't do this, but states might be able to do something about it. Continuing on, we're halfway through. We're halfway through the complaint. Withheld, retracted, or redacted documents referring to President Trump. The document failed to produce required documents referring to Donald Trump, retracted previously produced materials that showed or referred to Trump, and improperly redacted documents that referred to him. The department failed to produce documents relating to Trump that other sources confirm exist. DOJ isn't the only one with eyes on these files at this point. For instance, in one document, a woman accused Trump of forcing her to perform oral sex when she was a minor. That is... The FBI found this accusation sufficiently credible that it interviewed the alleged victim 4 times. I hate to say this, but I don't think those interviews were. I worry that too many people like Trooper Proctor are also in the FBI and that those were not pleasant. I mean, they wouldn't have been pleasant anyway, but I worry. 4 times makes me worry. The document goes on to say, according to logs, the Department of Justice previously produced 15 documents about this alleged victim to attorneys for Ghislaine Maxwell in preparation for her own defense, but only 7 such documents were produced under the Epstein Act. That's a massive discrepancy between discovery, I'm just going to say. Contemporary reporting suggests that the withheld materials include 53 pages of interview documents and notes. These remain unproduced. In another set of documents, a woman alleged that when she was 13 years old, Epstein introduced her to Trump at the latter's estate Mar-a-Lago. There, Epstein told Trump, quote, "This is a good one, huh?" End quote. Both men allegedly laughed, and then the girl said that she felt uncomfortable but didn't know why at the time. Oh, honey, because you were surrounded by creeps. An interview with the woman was initially published on the department website, but then taken down before being restored on February 19th, 2026. But multiple files cite other documents concerning the woman, which were produced to Maxwell but never made public under the Epstein Act. The department also retracted previously produced documents related to Trump. Sometimes it restored these documents to its productions after public outcry, other times it did not. For example, the document's first production of documents included an image of what appears to be Jeffrey Epstein's desk with 2 photographs of Donald Trump on it. Really? Ew. One with Epstein and Maxwell, the other with several women in revealing swimsuits. Doesn't make it better. The department removed the image from its website and restored it only after public outcry. Another document in the department's production included purported notes of interviews with victims and witnesses, one of whom, as mentioned above, alleged that Trump, we already heard that part. She further alleged that Epstein introduced her to Trump. This file, too, was taken down from the Justice Department website. Unlike the photograph mentioned above, it has not been restored to the department's website. In another document, Epstein wrote in an email that Trump said that while Epstein had never been a member of Mar-a-Lago, he'd never been asked to leave, contradicting later statements by Trump to the contrary. Congressman Jamie Raskin, who as a member of Congress was able to review the full unredacted document, reported that this document had been needlessly redacted. The department's violations have made it harder for plaintiff to do her job. Oh, why is Katie Fang suing? We are at the why is Katie Fang bringing this lawsuit, and how does she write that she has been damaged here? Because there has to be some sort of damage in order to get this through. So that this should be good. I'm also going to see if I can move this down. Oh, there we go. Now I can read and see you guys a little bit better and not be looking off to the side. I love it. The department's violations have made it harder for plaintiff to do her job. Katie Fang is an attorney and independent journalist. She graduated from Yale University and the University of Miami School of Law and has worked as a trial lawyer, serving as assistant state attorney in both Miami-Dade and Broward counties. She has extensive experience in civil litigation as well. While practicing law, she also began to work as a legal analyst for a variety of media outlets, including the local CBS Miami affiliate, Fox News, Fox Business, and then for NBC and MSNBC. From March 22nd through April 2025, she hosted the Katie Fang Show on MSNBC. As an independent journalist, Fang currently reports on legal news through her online YouTube news channel, Katie Fang News. Bonus points for a truly excellent plug in a public filing. Just gonna say. I and it goes on. And on a variety of other media platforms such as Substack. Fang has oh wait, did I miss a footnote? No, we're getting into yes, getting into the footnote. Fang has covered the crimes of Jeffrey Epstein, Ghislaine Maxwell, and others for years, in part because of the connections to her hometown of Miami. In just the past year, she has published dozens of videos, interviews, and reports about the Epstein files, Epstein's actions, his network, the government investigation into both, and the government's failure to fully comply with the Epstein Files Transparency Act. That's where the footnote comes in. Fang has also interviewed people connected to the Epstein tragedy, including at least one survivor. We're going to go to the footnote first before we continue. Also, I apparently have some catching up to do. I'm glad I linked her channel in the description of this video. This is a very long footnote. Oh, most of it is links. Okay. The footnote is pretty much links. She has a whole playlist, including 59 videos published over the last 9 months. All right. So if you're behind in all the details of what has been in the files, like myself, this right here, you can hit pause and find the links and oh, these are publicly available documents, so the links are all here. You can go do that. I love it when a court document has the links to all the videos. Going on to say, has personally reviewed many documents produced pursuant to the Act. The government's failure to comply with the Act has made it harder for Fang to do her job. With key documents redacted and with redactions entirely unexplained, it is difficult for Fang to understand and report about the meaning of the documents that have been produced. As with some of the documents retracted or never produced in the first place, it is impossible for her to understand and report about the full scope of the government's investigation. This is accurate, and I appreciate this legal angle of, hey, look, I'm an independent journalist. I can't do my job if the government doesn't do their job. The complaint goes on to say the Epstein Act was passed in part to help journalists like Fang do their jobs and expose those involved in Epstein's crimes. Case law, and other cited sources. We can skip over that. Unless the Department of Justice complies with the act, Fang will be unable to fully report the story of Jeffrey Epstein and the investigation into him, Ghislaine Maxwell, and their co-conspirators. She will also be unable to facilitate the transparency that is the purpose of the Epstein Act. As a journalist, Fang has a right to this information. She specifically is the beneficiary of and conduit for the transparency that is in the Act's very name. The department's failure to follow the law will hinder her mission as a journalist and make it impossible for her to do her job. Love that. Love that. And finally, the claims for relief. What does she want out of this lawsuit? So this is exactly what we're going to be putting up against the memo, the decision memo. So plaintiff incorporates the allegations in the preceding paragraphs as though fully set forth herein. Under the Administrative Procedure Act, a court, quote, shall hold unlawful and set aside agency action, end quote, found to be contrary to constitutional right, power, privilege, or immunity, or in excess of statutory jurisdiction, authority, or limitations, or short of statutory right. We have entered a section where I am not, and I don't have, I have not, I need a lawyer. I need a lawyer to explain that to me. So Katie probably does on her channel. I'm going to assume. She also asked defendants' production of materials under the Epstein Files Transparency Act is a final agency action. Specifically on January 30th, 2026, then Deputy Attorney General Todd Blanch wrote to Congress that today's production marks the department's compliance with its production obligations under the act. Defendant's production of materials under the act is not in accordance with the law because it is contrary to the requirements of that act as relevant to plaintiff. Defendant redacted documents in whole or in part that should not have been redacted. Defendant failed to explain the basis for these redactions as required by Section 2C2 of the Act. Defendant retracted documents referring to Donald Trump that ought to have been produced. So these are all things they want. What is the point of this lawsuit? To get the DOJ to release their shit. All the things that they have tried to put under the carpet, they need to release it. That I'm summarizing now. Okay. Yep. Okay. And what else do we want? Prayer for relief. This is what we want. The prayer for relief. Plaintiff respectfully requests that the court provide the following relief. 1, declare that defendant has failed to comply with the Epstein files. Make them say so. Make them say we didn't do it. 10 out of 10. 2, enjoin defendant's ongoing violation of the Epstein Files Transparency Act and specifically direct defendant to remove all unlawful redactions, explain the basis for any remaining lawful redactions, reproduce all materials that were produced but then unlawfully retracted, produce all materials that have not been produced that by law should be, oversee defendants' compliance with the law through appointment of a special master. Yes. I.e., we don't trust them to actually do this honestly. So we would like somebody to oversee everything and make sure that they do the things. 4, award plaintiff attorneys' fees and costs. That's almost always in there, but I'm here for it. 5, grant such other further relief as the court deems just and proper. Plaintiff demands a jury trial because that's usually how that goes. Not always, but usually. So that was the complaint. That was what she asked for. We have now heard that she won. I'm arguing to try and pull up the. Actually, while I'm getting the other document up, while we're pulling up the memorandum opinion, which I have not looked at any part of yet, I'm going to do a swoop. While we're doing the swoop, everybody take a sip, everybody take a little stretch. Now we're going to see what the judge had to say. And then that'll be our night. Where's my swoop? There's my. All right. I need to find. There it is. That's the one. Is that the one? That's the one. Yay. Okay. We had a little stretch. let's see what the judge had to say. Oh, hang on. Before I get into that, I hid chat for a minute, so I didn't see a chat come in. But Mandy is saying, Aurora, you've hidden things from yourself. Don't do that. Mandy coming in, appointing one person to oversee would also mean one person should be able to answer questions like why things have been redacted or haven't been released. Uh-huh. Uh-huh. This is the judge. We don't think they're gonna tell us the truth. So we need to have an adult in the room to make sure that they do all of the things and make sure that we get the reasons for why they did the things that they did, because we don't think that they're gonna we don't trust them. Yes. Oh, yes, like actual accountability. Yeah, like actual accountability. Like having like this administration needs an adult in the room. And I am hoping that the judge makes there be an adult in the room. Make the sleeves bags talk. Yes. Yes, I'm just administering. Like, can we send in some of our favorites to be like, now, like I need somebody, I need an attorney like Attorney Bloodworth or Attorney Alessi to be there going, I see these have names redacted and they shouldn't be redacted. Why did you redact them? Use your words. I want to know. We're going to have to file a motion that explains why you did what you did. 10 out of 10. I'm I'm gonna squirrel swoop and then let's see. I'm so curious what this judge had to say. I've only seen the headlines. Let's dive into it. Do we just want to find out if the judge is going to make there be an adult in the room? Yes. Yes. All right, get comfy. It's a long one. We will skip over what we can skip over, but I haven't actually like taken a look at this yet. So, I don't know what we can skip over. Aurora, should you have read this before you sat down to do your show? Yes. Did we have other things to do? Also, yes. Memorandum opinion responding to public demands for information. Congress with near unit. Aurora, words are hard. Words are hard. Unanimity. There we go. I got there. Passed the Epstein Files Transparency Act, the quote Epstein Act, on November 18th and 19th, 2025, which President Trump signed into law on November 19th, 2025. The Epstein Act is an unprecedented disclosure law requiring Attorney General, with few exceptions, to make publicly available. Sorry, I was just making sure that things are showing on screen as they should. To make publicly available in a searchable and downloadable database all unclassified Department of Justice files related to its investigation of the notorious sexual predator and child sex trafficker Jeffrey Epstein, the child sex trafficker Ghislaine Maxwell, and their associates. The Epstein Act required extremely timely compliance. The Attorney General was required to make the information publicly available by December 19th, 2025. The Attorney General made productions on December 19th, 20th, 22nd, and 23rd, 2025, and January 30th, 2026. Following the production of approximately 3.5 million pages of documents, the Attorney General announced that the department had complied with its production obligations under the Epstein Act on January 30th, 2026. Katie Fang, Ms. Fang, brings this action against Todd Blanch in his official capacity as acting Attorney General of the United States, claiming that he has improperly withheld information and failed to comply with other requirements in violation of the Epstein Act. Pending before the court is Ms. Fang's motion for preliminary injunction, in which she seeks relief for limited tests for a limited list of violations of the Epstein Act. The things upon careful consideration of Ms. Fang's motion, the Attorney General's opposition, the reply, the applicable law, and for the reasons discussed below, this court grants Ms. Fang's motion. Background, statutory and factual background, the Epstein Act. All right, this is so the judge had said Ms. Fang gets what she asked for. Not granted in part, denied in part, granted. And here's the reasons why. So this is the judge listing out why they did what they did. 1, the Epstein Act. The Epstein Act was passed by the House of, I'm skipping that word because I would trip over my own face tonight. By the House of Representatives on November 18th, 2025, by unanimous consent in the Senate on November 19th, 2025, and signed into law by President Trump on the same day. Done. Act went through, passed, done. It is, in fact, an act. They should do the things. It lists the bill number, last access June 22nd, 2026, reporting that the roll call vote in the House of Representatives was 427 yeas, ayes, and 1 no, and 5 not voting. Reporting passage in the Senate, so it gives the numbers for that in the Senate. It requires the release of documents relating to Mr. Epstein, subject to 5 permitted grounds for withholding, requires any redactions to be accompanied by written justification in the Federal Register and a report to Congress upon the completion of the release of records. Section 2A of the Act requires the Attorney General within 30 days after enactment and subject to the prohibited and permitted grounds for withholding to, quote, make publicly available in a searchable and downloadable format all unclassified records, documents, communications, and investigative materials in the possession of the Department of Justice, including the Federal Bureau of the FBI. Sorry, that was a little loud. And the United States Attorney's offices that relate to Jeffrey Epstein, including all investigations, prosecutions, or custodial matters. 2, Ghislaine Maxwell. 3, flight logs or travel records, including but not limited to manifests, itineraries, pilot records, and customs or immigration documentation for any aircraft, vessel, or vehicle owned, operated, or used by Jeffrey Epstein or any related entity. 4, individuals, including government officials named or referenced in connection with Epstein's criminal activities, civil settlements, immunity or plea agreements, or investigatory proceedings. Anybody he had dealings with in the government. Entities, corporate, nonprofit, academic, or governmental, with known or alleged ties to Epstein's trafficking or financial networks. 6, any immunity deals, non-prosecution agreements, plea bargains, or sealed settlements involving Epstein or his associates. 7, internal in DOJ communications, including emails, memos, meeting notes concerning decisions to charge, not charge, investigate, or decline to investigate Epstein or his associates. That's a big deal, by the way. I did not know that was there. I was following it, but I hadn't read this. The number 7, the internal DOJ communications. Am I going to relate everything back to Karen Reid? Yes. And Proctor? Also yes. The internal DOJ communications, that We wanna know what you really think. We want we want timeline, receipts, everything. We want it all. Ex um, all communications, and the reason for this is if there is an email out there, I'll come back to this in a minute, but if there is an email, an internal communication between a couple folks in the DOJ, let's say Trump, this is not something we know happened entirely. I'm basing it off of the Pam Bondi um tweet that Trump thought he was messaging her and wasn't. But if you get something like that where he actually is texting and saying, whatever you do, don't let this out. Um, and honestly, the internal DOJ communications could go, it could go back. I mean, if there is an email, am I going to throw Dems under the bus too? Absolutely. If there's an email from Merrick Garland saying we're going to decline to prosecute this, we just want this to go away. This is stuff that has to come out as well per this act, which I love. Mom says, have we reached half the population and 3/4 of businesses yet? I think we may have reached half of the government. I'm thinking probably we're getting there. We're working on it. Let me go back to the complaint because by the time I'm done, it might be all. We want all. Where was I? I was at 7, so we are moving on to 8. All communications, memoranda, directives, logs, or metadata. Oh, concerning the destruct. This is why you have young people in office, by the way. We know metadata is important. Or metadata concerning the destruction, deletion, alteration, misplacement, or concealment of documents, recordings, or electronic data related to Epstein, his associates, his detention and death, or any investigative files. 9, documentation of Epstein's detention or death, including incident reports, witness interviews, medical examiner files, autopsy reports, and written records detailing the circumstances and cause of death. We want all the information. Continuing on, Section 2B, entitled Prohibited Grounds for Withholding, provides that no record shall be withheld, delayed, or redacted on the basis of embarrassment, reputational harm, or political sensitivity, including any government official, public figure, or foreign dignitary. Again, I'm going to paraphrase. This is a lot of just summarizing what we've already read. So let's see. The 5 categories of permitted withholdings are records that A, contain personally identifiable information of victims or victims' personal and medical files, and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. B, depict or contain child abuse in any, yep. Yeah, we don't need to see any of these things. Would jeopardize an active federal investigation or ongoing prosecution. And depict or we don't want to traumatize the entire world. I'm going to summarize. We don't want to traumatize the entire world. And if there's national security stuff at play, which we know from Blanch's own filings that there wasn't. Section 2C also addresses classified information and requires the Attorney General to declassify such information to the maximum extent possible. Ooh, I didn't know that was in the act. Interesting. For information that cannot be declassified, the Attorney General is required to, quote, release an unclassified summary for each of the redacted or withheld classified information, end quote. Decisions to classify information covered by the Epstein Act after July 1st, 2025 shall be published in the Federal Register and committed to Congress, including the date of classification, the identity of the classifying authority, and an unclassified summary of the justification. That is that 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 is impressive. Okay. I mean, I knew this was expansive, but I am learning new things. Section 3, entitled Report to Congress, provides that within 15 days of the public release of the materials required by the Act, the Attorney General shall submit to the House and Senate committees on the judiciary a report listing 1, all categories of records released and withheld; 2, a summary of redactions made, including legal basis; 3, a list of all government officials and politically exposed persons named or referenced in the released materials, with no redactions permitted under subsection B1. The Attorney General's efforts to comply with the Epstein Act. Ooh, this might have some tea. The Epstein Act required the government to comply with its requirements by December 19th, 2025. Case law. Well, the act itself. On that date, the Attorney General issued a letter to Congress stating that the department was, quote, producing hundreds of thousands of pages of responsive materials in compliance with the act, end quote. Letter from Todd Blanch, Deputy U.S. Attorney General, to members of Congress at 1 December 19, 2025. Exhibit D to Ward Packard, things I do not understand at the moment. The letter stated that, quote, the department is continuing to review additional documents and other items for potential responsiveness. End quote. Noting that responsive documents are being provided to the department by the department's components on an ongoing basis. Oh, so he sent a letter saying we didn't get our homework done, but we'll get it to you later. Okay. I think I'm paraphrasing that correctly. Stated that in addition to withholdings and redactions permitted under Section 2C of the Epstein Act, the department, quote, withheld and redacted a limited amount of information otherwise covered by various privileges, including deliberative process privilege, work product privilege, and attorney-client privilege, end quote. See, this is where, okay, recall that Todd Blanch was Trump's personal defense attorney, which is a problem. But for anybody else, it's a problem because attorney-client privilege means that Blanch would be that Blanch doesn't have an out here. He did not think this all the way through well at all, because if he fails to do his job at the DOJ, then he's violating guidelines, ethical issues, all of that. If he does his job at the DOJ, but it means throwing Trump under the bus, then he's violating the attorney-client privilege with Trump. And as much as I do not like Trump, Blanch should keep that attorney-client privilege, which is why he shouldn't be anywhere near the DOJ. That was a side rant, sorry. And mom, yeah, did the dog eat the documents? I mean, I feel like even the dog would just I feel like all I can see in my head now is Joe Biden's dog Major just coming in and grabbing like a file box and dragging it to a judge and being like, "Here you go." Um all right, where were we? I am skimming a little bit because this is 48 pages. We've already been here an hour. Chat, do you want me to skip ahead? Chat, let me know. Let me know if we want to skim and zoom through this memorandum and then just skip ahead, jump to the end. Or if we want to keep reading. I will keep reading in the meantime. And I'm going to skip and skim where I can. Because this is a lot of facts, right? This is a lot of stuff we already heard in the complaint. So I'm gonna paraphrase a little bit. Privilege log will be produced in due course. Oh, this is more of the letter. Okay. The privilege log will be produced in due course. It didn't. And that the department will provide an explanation for any redacted and withheld materials as part of this production. We'll get you the things. We will. We promise. We promise to get you all the stuff. It sounds like they're taking lessons from folks in Massachusetts. The letter acknowledged that the department I jumped to here. The letter acknowledged that the department did not publicly produce all responsive material by the deadline, stating that, quote, the volume of materials to be reviewed, many of which continue to be produced to the Justice Management Division, means that the department must publicly produce responsive documents on a rolling basis, end quote. Right. So they're like, we know we didn't make the deadline, but we'll get it to you piecemeal as we feel like getting it to you. On January, and no production was accompanied by privilege law. Yes, I can do this. I'm going to try and pick out, I will try to just skim it because I'm trying to skip over case law and stuff like that. Yes, we will do this. Thanks, chat. Okay. Where was I? Okay. On January 30th, 2026, the Attorney General issued a second letter stating that day's production, quote, marked the department's compliance with its production obligations under the Act, end quote. Letter from Todd Blanch, read the Epstein Files Transparency Act. And that is Exhibit E. So, yeah, Todd Blanch wrote a letter and was like, we've done a lot, and more from the letter stating, quote, approximately 200,000 pages have been redacted or withheld based on various privileges, end quote. And that, quote, formal report with a summary of redactions made and list of all government officials and politically exposed persons named or referenced in the released materials will be submitted to the House and Senate committees on the judiciary within 15 days of today's release, end quote. It was January 30th, 2026. I feel like that never happened. I might be wrong. We're going to find out. The letter stated that the foreign language materials had not been reviewed or produced, quote, because it was not practicable for a first level reviewer to determine the responsiveness of a foreign language document, end quote. I heard this. Somebody else said this and it hurt my brain and I didn't want to believe it was real. And so I put it out of my head, but there it is. There it is. Because it was not practicable for a first level reviewer to determine the responsiveness of a foreign language document. Let me translate. We didn't want to find anybody who could translate it, and we didn't put it through even Google Translate to determine if it was something we needed to be looking at. We didn't feel like it, Your Honor. is basically what that sentence said. We didn't feel like reading another language or trying to figure it out. Google Translate is not like great, but it's not terrible either. I mean, it would take you, oh my God, I'm going to rant. I'm going to rant. Keep reading. We don't have time for me to rant. All right. I'm getting off my soapbox. The letter also stated that some documents were not produced because of technical issues with the files. That might be the dog that you were asking about, Mom. That the technical issues might be the dog ate my USB flash drive. It doesn't actually say that in the files, guys. If you're just listening, it does not actually say that in the document. Just say. I am using hyperbole. After submitting the formal report to Congress required under the Act and publishing the written justifications in the Federal Register, the department's obligations under the Epstein Act will be completed. On February 2nd, the Attorney General acknowledged that, quote, several thousands of documents and media may have inadvertently included victim identifying information and were disclosed in the January 30th, 2026 production and were therefore subsequently removed. Yeah, if I remember, they were removed after a whole bunch of people with eyeballs and reading skills said this is not okay. I'm going to be big mad by the end of this, aren't I? All right. Remember, Aurora, the motion was granted. Keep reading. On February 2nd, I already read that. Sorry. Where the lots of people. Yes. Letter, citation, the letter. Attorneys representing Mr. Epstein's victims informed the Maxwell court that the Attorney General's disclosure of victim identifying information began with the December 20th, 2025 production, that the impact to Mr. Epstein's victims from the disclosure had, quote, escalated from concern to suffering and fear for personal safety, end quote, and that the harm was irreversible. Yeah, because every single one of these victims got doxxed to high hell by people who apparently have with questionable morals, because anybody doxing anybody, in my own personal opinion, has questionable. Just don't go real life, and for heaven's sake, do not dox people. Especially not people who've already been through this level of stuff. Okay. On April 23rd, 2026, the department's inspector general announced that it had initiated an audit of the attorney general's compliance. So the inspector general said it was going to confirm if the attorney general actually complied or just said they complied. Okay. On February and it links to a news source. On February 14th, 2026, the Attorney General issued the report required in Section 3 of the Act in the form of a letter to the chairman and ranking members of the Senate Judiciary Committee and the House Judiciary Committee. See letter from Todd Blanch to Chairman Chuck Grassley, Ranking Member Dick Durbin, Chairman Jim Jordan, Ranking Member Jamie Raskin, Exhibit F to Ward Packard. So that is Exhibit F. With regard to withheld records, the letter stated that, quote, the only category of records withheld were those records where permitted withholdings under Section 2C and privileged materials were not segregable from material responsive under Section 2A. That was a lot of words, Aurora. What does that mean? I am not 100% sure because, again, not an attorney, but basically, the only category of records that were withheld were those we only kept apart the things you said we could, which we know is BS. The letter stated that no records were withheld or redacted on the basis of embarrassment, reputational harm, or political sensitivity, including to any government official, public figure, or foreign dignitary. Mhm. We know that's not true. So we know that in that letter was not the truth. Okay. And we know this because, in case you forgot, when Trump was on the campaign trail before he got elected for the second time, um, his plane broke down and he borrowed Epstein's plane. You kind of have to be good friends with the owner and their family and the keepers of their things if when your plane breaks down, you just borrow their plane. Okay, you just borrow your dead friend's plane. Sure. Um Perfect time for this, and I'm gonna add sure Jan. Sure Jan. That's uh-huh. Um, the letter included I'm going back to the document now. The letter included a 4-paragraph summary of redactions made and legal basis. The first category in the summary was the withholdings permitted under Section 2C of the Epstein Act. And for the second category, the letter stated that, quote, although permitted by Section 2C1E of the Act, no materials were redacted or withheld on the basis that that a record contained information specifically authorized under criteria established by an executive order to be kept secret in the interest of national defense or foreign policy and are in fact properly classified pursuant to such executive order. Ugh. Yeah. Two photos of him on the desk. Not just one, two. Yeah, but they weren't friends at all. Um, yeah, but they weren't friends at all. No. Um, okay, that was a lot of words. I can hear my dog barking in the background. She's having a moment. Um, basically to say, but if Trump said that we didn't have to turn it over because of national security, we don't turn it over. That was all those words to say that in that letter. Oh, but we're doing what we wanted. We're doing the thing, but we don't have control over whether or not this gets if Trump said that it's national security, it's national security. Right. Oh, and then privilege. And if it's not national security, I'm just paraphrasing this. If we didn't turn it over because of that, then it's privilege. And if we didn't turn it over because of that, the letter concluded with, quote, list of all government officials and politically exposed persons, end quote, named or referenced in the released materials. Mace, quit barking. Sorry, the dog is having a moment. If you hear her, my apologies. Plaintiff Katie Fang. Plaintiff Katie Fang is an attorney. So this is a summary of her. She's an attorney and journalist based in Florida. She's worked as a legal analyst. A lot of this is just in the filings. We don't need to do that. Let's see. T. Where's the T? All right. Since April 2025, she has reported on major domestic and international events with a focus on legal and political news on her YouTube channel and other platforms. She has, quote, extensively covered the crimes of Jeffrey Epstein, Ghislaine Maxwell, and others in the Epstein elite, end quote, including publishing 72 videos about the subject, all available in her playlist over on her YouTube channel, because I got to do the hustle thing for her. Because also it's here in the filing, which I kind of love. Her reporting on the Epstein files has realized more than 9.7 billion, 9 Aurora words are hard. 9.7 million views. Well done, Miss Katie Phang, on her YouTube channel. To conduct her recording, Ms. Fang has, quote, personally reviewed many of the documents produced pursuant to the act, end quote, and she has relied, quote, they're quoting her complaint. She has relied and continues to rely on materials disclosed under the act to develop her reporting and to prepare and execute her reporting. On a side personal note here, Katie Phang is an excellent reporter. She does a lot of work that I do not have the patience to do, and I appreciate reporters and legal analysts like her who are willing to sift through a mountain of shit that is these Epstein files to report to us the facts that they have found. Back to the memorandum. Okay. And the Attorney General's violations of the Epstein Act have interfered with her ability to perform her job as an investigative journalist. Yeah, if you can't get the materials, you can't do the job and you can't do the investigation. Specifically, the relief she seeks in her motion are, quote, particularly time sensitive because they are preventing her from moving forward with reporting she would otherwise conduct over the coming weeks and months, end quote. Ms. Fang seeks the information that she claims has been illegally withheld because as a journalist covering the Epstein story, she owes her audience, the public, and the victims of Epstein, Maxwell, and others the most accurate and comprehensive reporting possible. End quote. This is where not only the freedom of press, but the fact that we view the press as the fourth branch of government, because it absolutely is. Boom. That is what we're looking at here. The Attorney General's illegal conduct has injured and continues to injure her by preventing her from conducting the comprehensive reporting she would otherwise conduct about the specific information she seeks to obtain through her motion. Additionally, she states that the Attorney General's illegal conduct has caused and continues to cause her to suffer direct financial losses by constraining her ability to report on the Epstein files. I'm loving this so far. Procedural background. This is the background. We can skip procedural background because we just read the initial complaint and there's a few other things in there, but it's basically the complaint that we started the evening off with. We do have a footnote. The court does not address Ms. Fang's likelihood of success on her ultra-vires claim in this memorandum opinion because she does not invoke ultra-vires in the pending motion. Okay. So requiring the court enter an order requiring the Attorney General to show cause as why the redactions of sender and recipient names show cause, and there's a lot of numbers here that I'm not going to bother to read. Show cause why the redactions of potential co-conspirator names in the DOJ documents bearing Bates numbers should not be removed. Oh, those are Bates numbers. So these are I will explain Bates stamping at another point in time. Anyway, these are the numbers because when all this stuff comes into the DOJ, it gets Bates stamped, it gets a number so that you can cross check it and stuff like that. It's helpful when you have mountains and mountains of discovery like this. So there's a lot of show cause and immediately initiate review and production of foreign language materials that may be subject to production under the Transparency Act, and immediately publish in the Federal Register the redaction log required under the Epstein Files Transparency Act, and update it concurrently with each future release of redacted materials, i.e., bring all of this to light. This is all coming forward. The Attorney General filed his opposition to the motion on June 5th, 2026. Ms. Fang filed her reply on June 8th. If you want me to do a deep dive on this, we can go through the amended motions, replies, all of that. We can look at Todd Blanch's replies. If you want to wade into those waters, we can. Let me know in chat and in the comments below. Standard of review. A preliminary... I'm going to take a sip of water because apparently I'm having an issue with words. A preliminary injunction is an extraordinary remedy never awarded as of right, and only upon clear showing that the plaintiff is entitled to such relief. Case law. So it starts with a quote that basically says, I wouldn't be doing this if there was any reason, if there wasn't an extraordinary showing that the plaintiff is entitled. So we have entered extraordinary. The moving party, quote, must establish that he is likely to succeed on the merits, that he is likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in his favor, and that an injunction is in the public interest. So this is all, Katie Fang had to meet all of these, that the case would likely succeed on the merits, that she would suffer irreparable harm in the absence of some other preliminary relief, that the balance of equities tips in their favor, and basically, is it more likely or not that the facts are on Katie's side? If you are an attorney and I'm wrong on any of this, please let me know in the comments. I'm just a curious person that reads these things and figures some stuff out. And that an injunction is in the public interest. So that is a massive bar to get over, and it would seem that she did. I've lost my place. I'll get there again. Case law. Where the federal government is the opposing party, the balance of equities and public interest factors merge. Okay, that's good to know. In this circuit, the four factors have typically been evaluated on a sliding scale, such that if the movant makes an unusually strong showing on one of the factors, then it does not necessarily have to make as strong a showing on another factor. So if you come in with the evidence in your favor, whatever, that if one is overwhelming and one is maybe not as overwhelming, they're gonna go on the sliding scale there. In the wake of the Supreme Court's decision in Winter, I don't know that case, the DC Circuit has suggested that a positive showing on all four preliminary injunction factors may be required. Okay, so it used to be one thing, and then they want more. We read Winter at least to suggest, if not to hold, that a likelihood of success is an independent freestanding requirement for a preliminary injunction. Nonetheless, the circuit has no occasion to decide this question because it has not yet encountered a post-Winter case where preliminary injunction motions survived the less rigorous sliding scale analysis. Interesting. In the past, we have reserved the question whether the sliding scale approach remains valid. We follow the same approach here because even under the sliding scale approach, the movement must raise at least a serious legal question on the merits. Basically, at the very least, you have to most likely win on the merits. That's bare minimum. You have to get that. For reasons explained below, all factors weigh in Ms. Fang's favor. Analysis. This is where it starts to get good. The court likely has jurisdiction over Ms. Fang's claims. The Attorney General argues that the court lacks jurisdiction over Ms. Fang's claims because, one, the Act does not provide for a private right of action. Two, Ms. Fang lacks Article 3 standing. And three, the Administrative Procedures Act waiver of sovereign immunity does not apply here because Ms. Fang has an adequate remedy under the Freedom of Information Act. For the reasons explained below, each of the Attorney General's arguments is without merit. You are wrong, sir. Let us tell you why. 1. The APA provides Ms. Fang with a right of action. The Attorney General argues that by its own terms, nowhere does the Act expressly authorize private individuals to sue for alleged violations, nor does the statutory scheme indicate that Congress intended to create an implied right of action. And therefore, any claim premised on an alleged violation of the Act fails as a matter of law. However, Ms. Fang sues under the APA, not under the Epstein Act. The APA, by its terms, provides a right to judicial review of all final agency action for which there is no other adequate remedy in a court, and applies universally, except to the extent that 1. Statutes preclude judicial review, or 2. Agency action is committed to agency discretion by law. I can't get all of that, but whether she chose to file the lawsuit based on the Epstein Act or the APA makes a difference legally. And she chose correctly because she's a super smart attorney, too. The Attorney General has conceded that the production of documents was final agency action. Ms. Fang alleges that the Attorney General's violations of the Act are not in accordance with law pursuant to U.S. Code 706 because they are contrary to the requirements of the Act. Ms. Fang also alleges that the Attorney General's violations of the Act are arbitrary and capricious under codes because the Attorney General's production of materials, quotes, lacks a lawful basis, and because the Attorney General has not articulated an adequate, reasoned, or lawful basis for redacting documents in whole or in part, retracting documents, and failing to produce others, end quote. For all these reasons, the court rejects the Attorney General's argument that Ms. Fang's claims fail because the Act does not provide a private right of action. Ms. Fang has a right of action under the APA. Ms. Fang likely has Article 3 standing. Legal standard, case law. Article 3 of the Constitution limits the jurisdiction of federal courts to cases and controversies. One element of the case or controversy requirement is that plaintiffs must establish that they have standing to sue. So before anything goes anywhere, the plaintiff has to establish standing, which she did. Basically, Aurora, what is standing? Not everybody watches lawyers all day for fun. The standing is, I have a reason to be here. You should listen to me. I'm supposed to be here. To establish standing, a plaintiff must show an injury in fact, a sufficient causal connection between the injury and the conduct complained of, and a likelihood that the injury will still be redressed by a favorable decision. Rory could have just kept reading. The judge explains it. Probably because of the parties involved, specifically Blanch. Quote, since they are not mere pleading requirements, but rather an indispensable part of the plaintiff's case, each element must be supported in the same way as any other matter on which the plaintiff bears the burden of proof, i.e., with the manner and degree of evidence required at the successive stages of the litigation. So she also has to prove along the way. Courts have recognized that plaintiffs can establish standing based on informal injury. And an actual economic loss is a classic form of concrete and particularized harm that suffices by itself to ground Article 3 standing. She's proved it. She gets to be here. Analysis. Ms. Fang argues that she has two redressable injuries. First, she has suffered cognizable informational injuries. And second, she has suffered cognizable the first, she has suffered cognizable informational injuries. And two, she has suffered cognizable economic injuries. You didn't show me the stuff, and I can't do my job, therefore I'm missing out on money. Good argument, I have to say. Her economic is not suffering. The Attorney General responds that basically Todd Blanch responded with, no, you don't. None of those things is real. The court concludes that Ms. Fang likely suffers from informational injuries and her economic injury likely is redressable. So the court agrees with her and basically says she definitely suffered informational injuries. And as for the economic stuff, a court could probably figure that out. So, it is, how has she suffered the informational injury? It is well settled that a denial of access to information qualifies as an injury, in fact, where a statute on the claimant's reading requires that the information be publicly disclosed, and there is no reason to doubt their claim that the information would help them. To demonstrate that they have informational injury, a plaintiff must show that it has been, they must prove it. I'm going to skip over this because we're only on page 22. So they with anything in law, you allege it. In civil, you kind of have to prove it. The fact that a number of people could be similarly injured does not render the claim an impermissible generalized grievance. Basically, she's not the only one suffering here, but that doesn't matter. So, I'm trying not to miss anything important, but also zoom ever so slightly. I'm gonna zoom. Ms. Fang argues that she satisfies the first part of the test because she reads the statute to require a host of disclosures that have not occurred because disclosure is owed to the public at large. Fair. The Attorney General disagrees, arguing that Ms. Fang does not allege any harm or individualized interests separate from the interests of the public at large. Sir, that's not the argument you think it is. Okay. Two, she does not have personal statutory right to seek the information at issue. Because the statute is directed at the government, she has no legally protected interest to assert. The Attorney General's arguments are unpersuasive. As to his first argument, his reliance on Hein is inopposite since it is not an informational injury case. Okay. As to his second and third arguments, Center for Biological Diversity supports Ms. Fang's argument rather than his. Therefore, plaintiffs sued the U.S. International Development Finance Corporation, DFC, under the APA and the Sunshine Act, a statute directed at the government after the DFC published a rule exempting itself from the Sunshine Act. Congress enacted the Sunshine Act to open the deliberations of multi-member federal agencies to public view, end quote. It requires, among other things, a public announcement of meetings and logistical information about them, and the right to a transcript, recording, or minutes of any closed portion of a meeting. The court held that the Center for Biological Diversity had informational standing with regard to the first part of the test because, on its interpretation of the Sunshine Act, CBD claims that it was denied notice about certain meetings, preventing it from attending and engaging with DFC. The court explained that given Congress's clear command for any agency subject to the Sunshine Act to provide robust public information, there can be no doubt that these provisions create a right to information sufficient for the plaintiff's injury. As this court has explained, even if the statute entitles the public generally to the disclosure of the information from the government, that does not mean that the informational injury is not particular to plaintiffs. So even if it hurts a whole lot of people, it doesn't mean that it doesn't hurt the person who brought this at. Okay. The court concludes that Ms. Fang satisfies the first part of the test on her interpretation of the act. It requires the information to be disclosed to her as part of the public at large, and the Attorney General's alleged failure to comply with the law deprives her of this information. Correct. Ms. Fang argues that I'm skipping over case law things. Ms. Fang argues that she satisfies the second part of the test because she is suffering the type of harm that Congress sought to prevent in enacting the act. Ms. Fang argues first that Congress enacted the act to provide complete truth for survivors and to achieve a maximum possible level of transparency when it comes to the heinous crimes of Jeffrey Epstein. Ms. Fang then argues that to realize these goals, journalists, through their reporting, are able to mediate the contents of the files for the general public. She is absolutely correct there. The Attorney General disagrees, arguing that Ms. Fang cannot demonstrate downstream harm, some concrete consequences of not receiving the information, but that at best, Ms. Fang asserts generalized grievances of seeking complete truth and dude, you didn't do what the law said. And she's like, hey, follow the law, Attorney General. Okay. She has identified half a dozen stories she is currently able to report because the Attorney General has not disclosed information. Okay. The court concludes, I'm skipping ahead to the court's conclusion. The court concludes that Ms. Fang satisfies the second part of the test. She is suffering the type of harm, lack of transparency, that Congress sought to prevent by requiring disclosure of the information, and the disclosure of information that Ms. Fang seeks would help her in her work. For all these reasons, Ms. Fang has established that she is likely suffering from an informational injury. 2, Ms. Fang's economic injuries are likely redressable. So this is her argument. Does Attorney Blanch, we already read her argument. The Attorney General responds, I just want to see what Todd Blanch has to say, that any alleged economic injury cannot establish standing because it is not redressable. Monetary relief is not available under the APA. Oh, she'll be fine when she can make her videos. Trust me, sir. And rather, the plaintiff needs to show that her injury would be redressed by removing a hurdle. Ms. Fang is not seeking monetary damages. Yeah, she is requesting that the hurdle, the violations of the act, be removed so she continued to publish her work. Yep. Her economy injury is redressable by the relief she requests. Okay. Judge is like, yeah, no, but if we do the things and if you turn over the things, she can make her videos and then the financial thing is solved. Ms. Fang has likely established the requisite causal connection and her informational injury is likely redressable. Attorney General does not contest causal connection, which is easily met here. Fang's injuries are directly traceable to her claims that the Attorney General has violated the Epstein Act. The Attorney General also does not dispute that Ms. Fang's informational injuries are redressable by the relief she is seeking. So if you don't dispute it, it's a thing, the court can go with you. For all the reasons discussed above, the court concludes that Ms. Fang has established Article 3 standing. You're allowed to be here. 3, FOIA does not provide an adequate remedy. The Attorney General argues that Ms. Fang invoked the APA's waiver of sovereign immunity when she brought this action under the APA, but because FOIA provides Ms. Fang with another adequate remedy, there was no waiver of sovereign immunity, and so the court lacks jurisdiction over her claims. I'm going to guess that what we're going to see here is that is not, in fact, how things work because FOIA doesn't cover it. FOIA doesn't necessarily cover it. For a remedy to constitute an adequate remedy, precluding APA review, the remedy must not be doubtful. Okay. The disclosure mandate in the Epstein Act is strikingly broad. Yeah. The court concludes that FOIA, a fundamentally different disclosure law, does not provide Ms. Fang with an adequate remedy for the reasons explained below. So FOIA wouldn't do it. So first, Ms. Fang likely would not be able to obtain the unredacted names of senders and recipients in email exchanges, correct? Because such information would likely be redacted under FOIA Exemption 6. Information that, if disclosed, would invade another individual's personal privacy. And FOIA Exemption 7, information compiled for law enforcement purposes, correct? FOIA is not necessarily going to cover these things. You can't get like sealed documents through FOIA, and the Epstein Act is much broader. Second, she would not be able to obtain unredacted DOJ internal charging documents, right, or the notes of the interview with the person who accused Mr. Trump, because they would likely be subject to the same exemptions. Yeah, a lot of these aren't going to come out because of FOIA. Okay. Third, she likely would not be able to compel the review of foreign language documents because such a request likely would be denied as unduly burdensome. Right. I'm looking to see what the judge says. We know that the judge is in agreement, but I'm skipping ahead. because this is all just an explanation of why FOIA would not be the remedy. Oh, this looks good. The Attorney General relies on a string cite to assert that FOIA provides an adequate remedy here. But the Attorney General does not even attempt to explain why the cases cited are analogous to this case, where the Epstein Act mandates broad disclosures that would be exempted under FOIA and requires the publication of a redaction log that the Attorney General has not yet published. So he's basically, Blanch is saying, I, that FOIA is good enough, but then doesn't explain his argument to the court. Okay. The Attorney General argues that the Epstein Act and FOIA must be construed as a whole, and indeed they operate in harmony. No, they don't. But he provides no authority for these propositions. He contends that the Act supplements FOIA by imposing additional disclosure obligations with respect to a specific set of records. It does not supplant FOIA or create a parallel enforcement framework. Oh, that's just wrong. He provides no authority for these propositions either. Keep reading, Aurora. The Epstein Act is a standalone piece of legislation. It does not reference FOIA or modify the FOIA provisions of the United States Code. When enacting the Epstein Act, Congress was well aware of FOIA and its requirements and, quote, thereby indicating that it did not view the alternatives to the same information as adequate. Yeah. As the plaintiff sought to enforce the disclosure statute through the APA. Attorney General asserts that Ms. Fang alleges that the department's public disclosures violated the law by failing to produce required records, improperly withholding information, and neglecting to provide adequate justification for any redactions applied. Sure. Which is similar to what plaintiff would contest under FOIA. I mean, yeah, but huh? No. Um, I'm jumping ahead to the court here. The court held that FOIA offered an adequate remedy. Oh, this is all explaining their sources. I'm going to skip over this for now. Cuz it's getting late. But I'm going to skip over this for now. The Attorney General also points to that I'm down here. If you're following along with your eyes and if you're just listening, I'm jumping over sections because I'm trying to get to page 48 before we've been here for many hours. And we are at page 34. So we're zooming along, but there are some things I'm trying to skip past. The Attorney General also points to the department's crosswalk that correlates the exemptions under the Epstein Act to the FOIA exemptions. Right. Okay. So for all of these reasons, some of which I have skipped over, it is highly doubtful that FOIA could provide an adequate remedy. Therefore, Ms. Fang's suit under the APA is proper and is not barred by sovereign immunity. We're going to zoom through the end, guys, unless I see something real juicy. Ms. Fang is likely to prevail on her Administrative Procedure Act claims relevant to the pending motion. So it goes through her argument. It goes through Blanch's argument. Let's see where we are. So I'm just going to read to the end because this is how many of these have started. The Attorney General does not respond substantively to any of these arguments. Rather, he states that based on his jurisdictional arguments, Ms. Fang's APA claims fail as a matter of law. By not responding substantively, the Attorney General has conceded that Ms. Fang's merits arguments in the pending motion, stating that stating that DDC Local Rule 7B is understood to mean that if a party files an opposition to a motion and therein addresses only some of the movant's arguments, the court may treat the unaddressed arguments as conceded. Basically, if you do not mention it, you just avoid the situation altogether, the court can assume that you, in fact, agree with what the plaintiffs had said about that thing. Interesting. Ms. Fang likely has established that she faces irreparable harm. They go through her arguments, they go through his arguments. This court concludes that Ms. Fang has demonstrated irreparable injury for the reasons explained below. 1. Ms. Fang's informational injury is neither speculative nor conjectural. Her argument, Attorney General argues that Ms. Fang has not provided adequate evidence that any records are presently at risk of destruction, that any relevant evidence is likely to be lost during the pendency of this litigation, or that any witness possess information that is in imminent danger of becoming unavailable. This argument is beside the point. Yeah, Ms. Fang does not argue that she faces irreparable harm because the records are at risk of destruction. That evidence will be lost during the litigation, or that a witness will possess information that is in imminent danger of becoming unavailable. Rather, she points out that these are concerns with any potential judicial redress for victims. The Attorney General also argues that the fact that many of the records at issue concern alleged events that occurred decades ago undermines her claim of urgency. However, the urgency is based on the fact that the Epstein Act required disclosure within 30 days of enactment, not based on when the underlying events occurred. Finally, the Attorney General argues that Ms. Fang's argument regarding public interest fading after the upcoming midterm elections is speculative, to say the least. However, the non-disclosure of information to which a plaintiff is entitled under certain circumstances itself constitutes an irreparable harm. The footnote says the Attorney General also argues that injury from delay in obtaining these materials is speculative. And there's more to that, but I'm skipping ahead. Specifically where the information is highly relevant to an ongoing and highly public matter. Right. All right. So the court based on this, another example was because the urgency with which the plaintiff makes its FOIA request is predicted on a matter of current national debate. Due to the impending election, a likelihood for irreparable harm exists if the plaintiff's FOIA request does not receive expedited treatment. Here, the current high level of interest in the Epstein files, combined with the upcoming midterm elections, amounts to a circumstance that itself constitutes irreparable harm, especially where the Attorney General has not disputed that he is in violation of the act. 2, Ms. Fang's economic injury is irreparable. So, I'm skipping. I'm zooming. The Attorney General argues that Ms. Fang has acknowledged. I'm zooming to basically the final punch paragraph because 42 of 48, we're almost there, guys. The Attorney General argues that Ms. Fang has acknowledged that she has continued to publish on her YouTube channel and has not been prevented from covering the Epstein matter generally. No, but you can't do a deep dive on if you don't have Blanch. That's not how discovery works, even if it's not a legal proceeding. Plaintiff released an episode just 2 months ago that recorded over 315,000 views to date. Get those numbers up, guys. And another 3 months ago I haven't checked the numbers today, that recorded over 841,000 views to date, has shown that the absence of these records has not silenced her. That's not what she was saying. However, that Ms. Fang has continued to work does not mean that the economic harm is irreparable for the reasons explained above, and because she would do additional reporting based on the information she seeks. Yep. Ms. Fang did not delay seeking preliminary injunctive relief. A party requesting a preliminary injunction must generally show reasonable diligence, case law, while a late filing on its own is not a permissible basis for denying a preliminary injunction. Ultimately, filings may support a conclusion that the plaintiff cannot satisfy the irreparable harm prong. Basically, she filed it real fast, so yeah. The Attorney General argues that Ms. Fang's delay in seeking injunctive relief further undermines she waited until it's late, I'm tired. She waited until she had all the information, then she filed for injunctive relief. And Todd Blanch is saying, you waited too long. He argues that she had the information that forms the basis of her claims in early February 2026, but did not file suit until. That's like, okay, sure, but did not file suit until April 27th, 2026, and then did not file her motion for preliminary injunction until May 28th, 2026. Ms. Fang responds that there was no delay because the scope of the production meant that it took weeks to discover the gaps in the productions, and not having the redaction log complicated that task. Basically, you can't know what you don't know, particularly when you're just handed. This is the equivalent, the amount of files here, it is the equivalent of showing up at somebody's house with like 5 full filing cabinets that have no order and no filing system at all. It's just documents. And they say, here, find the information you're looking for. What this act is asking for, and this suit is asking for, is put the shit in file folders, guys, and then hand us an index of it so that we can go find it. Okay. Ms. Fang responds, there was no delay. I read that already. On January 30th, 2026, the department announced that as of that date, it had published approximately 3.5 million pages. Yeah. Well, we publish stuff. No, you not the way you're supposed to. Ms. Fang states that she promptly filed this lawsuit after discovering and confirming the scope of the Attorney General's non-compliance, but she delayed motion practice in the hope that the DOJ would quickly cure its most blatant errors, or at least negotiate over them. But a month into the case, the government has not entered a notice of appearance, and so she filed the motion. Ms. Fang filed suit approximately 4 months after the Attorney General completed the disclosure of the 3.5 million documents, and she filed the pending motion approximately 1 month later. In view of the volume of documents and the failure of the Attorney General to publish the redaction log, Ms. Fang's conduct does not constitute delay. I'm almost done, Macy. I'm almost done. I'm almost done, honey. The dog is telling me I need to be done. She is not a fan of long shows. No, she's not. You should come up and say hi to the internet. Okay. The balance of equities in the public. Oh, if her shows are not on, if anybody in the house is listening to me, if her shows are not on, that might be part of the restless problem. I feel like her shows might not be on. All right, where are we? The balance of the equities and the public interest favor an injunction. Injunction. What does the court say? I'm skipping over what they said. We already know. The Epstein Act requires the actually wait, however, there is no competing harm to the government with the issue of preliminary relief that orders compliance with statutes and the Constitution, while there is substantial public interest in having governmental agencies abide by the federal laws that govern their existence and operations. Yeah, there is a substantial public interest in having governmental agencies follow the law. For all these reasons, again, I'm skipping over a bunch of things to get to what the court has to say because the dog is done. For all of these reasons, the court concludes that the balance of the equities weighs in favor of entering a preliminary injunction. E. The court imposes a nominal bond on Ms. Fang. The federal rules of civil procedure, I will read a lot of this because it is kind of important to this, provide that the court may issue a preliminary injunction only if the movement gives security in an amount that the court considers proper to pay the costs and damages sustained by any party found to have been wrongfully enjoined or restrained. Courts in this district have found this rule vests broad discretion in the district court to determine the appropriate amount of an injunction bond, i.e., put up or shut up. So you're claiming these things. The court is going to determine a certain amount of money that will go into a bond that basically says, if this is dumb, if this is frivolous, you're going to lose this money. If, however, you are making this argument in good faith, other things can happen. So, yeah, that. Federal courts typically require substantial bonds only in suits between private parties with significant monetary interests at stake. So it will be money, but not that much. A bond is not necessary where requiring one would have the effect of denying the plaintiffs their right to judicial review of administrative action. The Court of Appeals for the District, there's a lot of case law and stuff. The Court of Appeals for the District of Columbia Circuit Court recently clarified that injunction bonds are generally required under Rule 65C to ensure that the imposition of a bond does not unduly burden plaintiffs, impair the ability to seek judicial relief, and chill access to justice, i.e., it has to be an amount where it's scary enough, but not too scary, if that makes sense. Sorry, my eyes are hurting me at the moment. Basically, it's why we add punitive damages to things like the Cardi B trial that we went over on the other channel. That. Because that's why punitive damages exist, because in a case like that, like, you're not gonna have any punitive damages, but if Cardi had counterclaimed, yeah, I could see that a jury would have found in favor of Cardi. There we are. The court agrees that anything more than a nominal bond would prejudice Ms. Fang and potentially create a chilling effect on other public law plaintiffs, i.e., if I ask for too much of Ms. Fang, it's going to chill other people from also filing lawsuits. Interesting. There's some subtext there. Furthermore, the Attorney General has not shown that if the court grants preliminary relief, the department will incur any significant costs or damages. Therefore, keep reading, Aurora. The law says you have to put up money. However, therefore, the court joins other judges in this district and imposes a nominal $1 bond. Okay. The court will not issue a stay. The Attorney General requests a stay of 7 days to determine whether to seek emergency appellate review, i.e., Judge Alito, will you do what we ask you to, and we can get away from the scary, smart lady who is holding our feet to the fire? The Attorney General also requests a stay of 60 days to determine whether further appellate review is warranted. No. The court will not issue a stay for the reasons stated in this memorandum opinion. You didn't convince me. She had the facts. You had, but Mom, that does not work. I'm paraphrasing for the judge. Oh, yeah. The Attorney General has conceded that he is in violation of the act. That's the other thing. Like, Ms. Fang is not requesting the immediate production of the documents, but rather that the Attorney General show cause if he declines to do so. As to the request of review of foreign language documents and publish the redaction log, the act required the Attorney General to produce the documents and publish the log by December 19th, 2025, more than 6 months ago. Conclusion. For the foregoing reasons, the court grants Ms. Fang's motion for preliminary injunction. An appropriate order accompanies this memorandum opinion. So ordered, signed, Emmett G. Sullivan, United States District Judge, June 25th, 2026. I didn't mean to make me disappear. I meant to embiggen me. Swoop. All right, chat. So, if I can paraphrase, attorney, legal analyst, and independent reporter Katie Fang sued the DOJ, sued the Department of Justice, specifically Todd Blanch, in his acting attorney general status for release of the Epstein files. Todd Blanch said, "Nuh-uh, what you gonna do about it?" Katie Fang said, bet. And she went to court and she presented, she presented her evidence. And Todd Blanch kept agreeing with her. Maybe not the best opportune moments for him. I don't know what that sentence was. Mercury goes into retrograde on Monday. Anyway. So Todd Blanch actually conceded a whole lot. Never mind the conflict problem with him in his capacity as AG. And the judge looked at the evidence and said, Blanch, your arguments suck. Katie Fang actually brought the receipts. And so you are going to have to do the thing. And if you do not do the thing, you are going to actually have to do the work that the DOJ has not done at this point. You have to do the indexing. You have to do all of this stuff. And so far, from what I've heard, things are in fact starting to file out of the DOJ now. And because there's a more sharp time limit on it, because there is a bit of a concern of things being destroyed. So that is in the works. The judge looked at both sides, looked at Todd Blanch, and went, your argument sucks. I'm not doing it that way. Katie Fang has produced every receipt I could possibly want. So it is likely that she would win on that. This is just the injunctive relief. There are other things going on with this case. I do not think this is looking at this again. I'm not sure this is the end of the case, so we can keep it on our docket. Nope, I need to swoop before I continue with that. Anyway, that is what we're looking at. Katie Fang, nobody else is doing anything about this. I'm going to sue you. Todd Blanch, I know what you are, but what am I? Judge. Children? No. Blanch, go do what you said you needed to do. Ms. Fang, excellent job. that's my summary. Swoop. 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 All right. And now, you guys are amazing. Thank you, chat. Thanks for hanging out with me. First run of documents is always a challenge. This is why I end up listening to 4-hour streams. Shout out if you've hung out with me all this time. I know for a lot of you, you like it at an hour. I can't do 48 pages of documents in an hour. I can't. But don't worry. That's why I did the summary at the end. I will clip things down over the course of the next week and try and get some shorter bits up for you. Pardon me, it usually takes me a day or two, and then there's timestamps as well, so you can just hop ahead. Pardon me, good heavens. So, all of those things are coming. So, in the next couple days, you'll be able to see that in the description of my video here. I do have Katie Fang's YouTube channel. I know I'm going to go check out a whole bunch of that. And I think you should too if you're interested in this. If you're not on the email list, barkslotmedia.com, that is where you can get on the email list. That's where you get the front end of the information here. Also, I have a whole ton of options for coverage when we're back after the holiday. So I think I will probably post them on Threads or something later. But anyway, let me know in the comments. Or I can, you know what? I'll do a post in a day or so with all the things we're looking at. Please let me know what you want to dive into next. There is so much court happening. There's political things happening. There's a whole ton of things. And with that, you guys are awesome. Thank you for hanging out here. As always, everybody, I need to find my button. Need to find the button. Be well. Do good. Have a great 4th of July, everybody. If you If you are celebrating, yay. If you are celebrating the way I am, let me just show you my my reflecting pool, my homage of the reflecting pool nails. So, and yes, I'm aware. I'm aware of which nail they are on. It was intentional. That's my vibes. May you have whatever 4th of July, if you're in the States, vibes that work best for you. I will see you not next week, the week after. I'll try and do something in the maybe we'll do a bonus stream. I don't know. We'll see what the month has in store. Be well. Do good. Have a good long weekend at the very least. And remember to bark a lot. I will see you. Don't hit the mic, Aurora. Don't do that. You were saying a lovely goodbye. I'll see you on the next one. Thank you. Bark. Thank you for joining us for another episode of Bark a Lot. Follow me on Threads and Insta at the Aurora H. White. That's where I post most frequently between shows. Hit that like button, connect with us, and remember to bark a lot. We will see you next time.